Legalities with your host Zainab Zaeem-Sattar on Ramadan Radio 87.7 FM. So before I take the time to introduce our guest, I will do a little bit of housekeeping. So this show is interactive. Feel free to chat to us through Facebook on Ramadan Radio FM, or you can send a text message or WhatsApp us on 077 488 55055. Or you can always email us on info@ramadan.fm. So as you already know, I do have a show called Breaking Stereotypes, as well as another show called Law in Action. So today's show is a little bit different from my Breaking Stereotypes. So I do want to take the time this morning to thank all those people, everybody who's tuned in, everyone who's supported the team at Ramadan Radio, and all my guests, because without any of you, these shows would not take place. So jazakallah so much. Now, without further ado, today I have somebody who I personally know, a beautiful young lady called Yasmin Hook. She is a solicitor. She runs her own firm. She's an advocate for Islamic wills and other areas as well. And I've recently come to learn that she's completed various courses on the fiqh, on inheritance, and is currently doing a 6-year alima degree. MashaAllah. Assalamu alaikum, Yasmin.
Walaikum salam, sister. Thank you for a lovely introduction.
Oh, no, you're most welcome. I'm not doing you justice, to be fair, because I'm sure there's a lot more that I've not covered. Now, tell us a little bit about you and your firm before we start getting into the nitty-gritty of today's topic.
Sure. So I've been in the legal industry for a long time, working for others, doing different areas of law. And I guess my study of Islam and the Islamic sciences led me to set up a new practice, ALHQ Law. And the focus of it is bringing kind of Islamic sacred values, how I feel that they are quite sacred to us as Muslims, and bringing them into real life practical legal solutions. So I first actually searched for others doing this already, because I thought I must not be the first person who's thought of Islamic wills or, Islamic laws and how they can apply nationally, internationally, or personally even. But everyone that I kind of reached out to were doing it in a slightly different way. So how I was thinking about it or wanted to deliver it for my clients, it wasn't really happening, or I didn't feel it was happening. So I'll probably explain that a bit later, but that led me to set up the practice, ALHQ Law. And really, really happy. I feel so much more content now being in the legal industry with this practice that I've got, and feeling that I'm kind of doing something which is true to my beliefs, as well as fulfilling, the criteria of being a lawyer. So the best interests of your client, giving them informed choices about what's out there in terms of a solution to any legal problem. So that's where it came all about, really.
Well, can I just say that what you've actually said resonates quite a bit with me, because some of my listeners are fully aware from some of the shows that I've been doing recently that when I first qualified as a solicitor, because I've only been qualified 3 years, but I bring to the table 20 odd years worth of work experience. And when I qualified, my nanny Mao, who Allah Ta'ala give her the highest place in Jannatul Firdaus, but she visited the UK from India that particular year that I'd qualified. And we were chilling out in a dawat, and we sat and we were talking, and in Gujarati, she goes to me, I'm so pleased that you've become a lawyer. MashaAllah, I'm so happy for you. But beta, a lawyer? Of all the jobs in the world, a lawyer, you have to lie so much.
Oh.
And I, looked at her and I was in shock, and I said, Nanima, this is not the same as lawyers in India or somewhere who, can be corrupt. Not every lawyer is corrupt in India, but there will be the odd occasion that will be. And I said, Nanima, we can't do that here. There are very strict rules and regulations. And then it sparked a conversation about, Islam and whether or not the criteria that we have to meet in law, does it actually clash with Islam? And actually, it's very similar in line. The criteria that Islam lays down about honesty and transparency, you know, that's the rules that the Solicitors Regulation Authority, the SRA, who regulate solicitors, and the Bar Standards Board, BSB, who regulate barristers, who dictate to us. So it's actually very similar as opposed to the two clashing. So your firm itself, are you able to tell me exactly what areas that you cover?
So I guess on that a little bit, I think there's a bit of myth busting to do in terms of, you know, the impression of lawyers being liars and things. I think it stems from, you know, you have to represent someone.
Yes.
So you can't necessarily disclose everything in a court because you wouldn't be acting in their best interest to disclose everything, although you may know it yourself as a lawyer. You have the kind of, you know, you'll know about the privileges, something which is pending litigation, or, you know, if you're going to a round table meeting where it's without prejudice and you can have that discussion. So that's what I've kind of tapped in, is when you're not in that adversarial court system, because having been in litigation and worked at firms doing corporate, commercial, catastrophic injury type work where you are pitted against each other. Here in my practice, it's all about what can we do with each other as people, communities, and knowing about the law. So we're not going outside of the rules and regulations, but we're not putting ourselves in a situation where we may have to be working against each other. So communication has broken down. You are unhappy with something, so you're needing to claim, or you're needing a judge to decide a matter. And in that situation, I think the lawyers get a bad press because you are pitted against each other and you have to lay what you can lay before the judge to decide.
Absolutely.
And that wouldn't be as open as cooperative as it would be if you're outside of the courtroom and you're in a mediation, or you're in a without prejudice discussion. So my practice seeks to do all of the kind of areas of law that you can do without having to go to court. So I network and collaborate with lawyers who are qualified in contentious probate, which is in the area of wills law. If you don't agree with what your inheritance should be, or if you feel that something has gone wrong or hasn't been done correctly, then I would collaborate with other law firms to then take it to the next step, where my practice wouldn't go to that step, because I firmly believe that reaching out to people on just a human level and a normal person-to-person basis, you are open with them about the facts, about the law, and about where you could end up, i.e. very expensive and very lengthy litigation or court proceedings to get a judgment that you may not even be happy with or feel that you've actually achieved justice. Absolutely, so what do? We're rewinding a few steps back, and we're creating I've created a practice here where you can think about things. So with wills, for example, the first step I've taken is to set up a service that you can implement your wishes in legally binding documents, with consultation with your family members, or those. So it's not like a sneaky underhand, I'm just doing it because I can. It's very much a community-based, family-based approach where you're informing others. This is what I'm doing, guys. Are you happy with it? Now is the time to speak up. Give them the opportunity, and then not kind of shut people down. So be fair to them, hear them out, why they want it this way or that way. Ultimately, you're doing the will to benefit them, and they inherit. So they should be happy with it. It shouldn't be a cause for fighting or upset later on, because, you know, ultimately someone passes away, and it's sad enough as it is. So in that area of law, I want it to be like a positive and a productive experience when you first have that consultation. Cost shouldn't necessarily be a barrier, because if you don't have a very complicated estate, for example, I feel the service should offer you options that you can do something in a cost-effective way. But then also, I take the time to learn about the tax and trust rules and ensure I am providing a service which is regulated. So if you have something which is complex, you've got multiple properties, multiple family members, different disagreements that could happen, you can still create a will which is legally binding. You'd pay a bit more for it because you need to, but it's going to save, the outcomes which you'll be familiar with, where you're at court and it's thousands and thousands of pounds. It's a very lengthy procedure, and it eats away at what should have been a pleasant experience you're inheriting. So that's that one service. And then the other service is a weekly clinic where you can come to ALHQ law with any kind of legal issue that you might be facing. And particularly, I think people who are from the Muslim community or ethnic minority, or it could just be an average person that isn't kind of well versed in what the law says about certain things. So they have a confused idea of what they want to achieve, so they can get access a 30-minute consultation just to know where they stand and what they can do. And often it's a platform to then provide you with a specialist in a certain field, knowing that you haven't been sent down the wrong path because you've been searching yourself, or you've kind of gone with a recommendation but it wasn't really suitable for you. It's an independent, objective assessment of your legal issue, and then connecting you to a specialist, whether it's family law, contract law, who will respect your wishes, like religious wishes, cultural wishes, and they are a qualified professional. So you're still getting a high class service, but you're not missing out on that kind of, I think of it more like, when you approach a GP and you're not sure what the diagnosis is. And sometimes even the GP is not really sure either, but just talking it through with a professional and then figuring out which of the legal paths you should go down, because often at that early stage you do have lots of choice, and if you ignore something, or if you let it escalate into people getting sad with each other, doing things that they wouldn't normally do because they think it's the right thing legally to do, and then ending up in a kind of tangled mess which is much harder to fix. So that aspect of the clinic is growing as well. And then the will writing service, of course, is growing to cover the full spectrum as much as we can.
Brilliant. So alhamdulillah, there's a lot of items there that you cover. Now, I do want to start talking about Islamic wills, but before I do, there was a terminology that you mentioned, which was without prejudice. Now, for my listeners, those who have tuned in who might not know what without prejudice means, do you want to give a quick explanation, please?
So in normal proceedings, I guess the best plain English way of describing it is that you can say whatever you want and no one can hold it against you. So it's a free, open, honest, everything you can say, whatever you want to say, you can write it out or you can speak it out, and it should stay in that meeting or in that correspondence, and that doesn't get viewed later on in any claim that you do want to proceed. So you always have that right as an individual. In England and Wales, the legal system jurisdiction provides you with the right to take a matter to court, to get the judgment from the court. So we can't take that away from you. But without prejudice is the chance to just say or write, make offers, for example. So you might think, if this case goes to court, I could end up having to pay £50,000 or something to this person because that's their share. So I know that, and I'll tell them that that's what I think. So I'll offer them something like £45,000 or £40,000 now if they take it, rather than forcing me to go down the court route where they'll also not only have to take the risk whether they might get the 50 or not, but they might have to pay 20,000, 30,000 in costs. So, it's not
in legal
just
fees.
Kind of, but having a chance to work out what's best for you, good for you. I encourage people to engage in that kind of meeting. And
so what stays in Paris, what happens in Paris stays in Paris, that terminology.
Exactly.
Absolutely. So we've talked quite a bit about the wills. One of the first topic we've talked a lot about what you do. What I want to clarify is, first of all, what is a will? Because whilst we might appreciate that it's a well-known area, actually not a lot of people might know what it is. So are you able to tell us exactly what is a will?
So in simple terms, it's a wish that has been written down. So if you're saying it verbally, it's not legally valid to be defined as a will. But as long as it's in writing and it's been witnessed, that is your wish, essentially, in a legal enforceable way. It becomes a will. So it could be an idea, it could be a wish, and it turns into a will through you writing it down in the correct formality way.
Okay, great. Now we have recently been hearing the terminology Islamic will. So let's say we've got the Western will, so you got the English common law will, and then you got your Islamic will. So what is an Islamic will?
So that's what I noticed as well, sister, when I went into this area, that there was this terminology about Islamic will. So that led me to research about it and study it and find out. But actually, it is a will. So the definition of the will, which I've described, which is your wish and your intention, what you want to do, and you put it in writing, it's the same thing. But with England and Wales, what we should know about is that you have full freedom. So there's no kind of forced position of I have to leave everything to certain people in certain shares, which is different to, for example, Scotland or other European countries, and maybe even countries in the Middle East and further afield. They will have a system of forced succession. So I guess to explain, that means that the government or the court has already said, if someone passes away, this is how it's going to go. And if somebody doesn't agree, there may be routes to challenge. But in England, it's more free in the sense that an English will or English and Welsh will, you can write it how you please. But there are laws in place. If someone's unhappy, they can then go and challenge that and rejig what has happened there, if they think somebody was influenced or that somebody wasn't of the right sound mind when they did it or something, or they missed out on a share that they were promised, and all of those kind of mechanisms are there. But ultimately for the person, it's totally free. Now, from the Islamic point of view, we as Muslim believers take our instructions for prayer, fasting, zakat. Where do we go? We, of course, go to the Quran and Sunnah to provide us with guidance on how we can fulfill our religious obligations. So those are the common things we get taught and we know about. But I think inheritance, certainly I can't remember when I studied the basics of Muslim life, if you like, while I'm doing my normal education study, about inheritance. It was not even a thing. I don't know if that was just me or it didn't come up anyway, or I must have missed it, but it wasn't thought of as something that we would get taught as part of the general things to know about. But it is quite important.
Yeah, well, I was actually going to say that looks like you and I have had slightly different teachings there, because the mosque that I used to attend when I was growing up in Bolton, we prayed a kitab known as Bahist-e-Zevar, which was a very, very thick kitab and fully in Urdu. And in there, it actually does teach us about inheritance. So from a very young age, it was drilled into us that women should expect a certain amount, or this is what their share will be, and men should be getting this. And the reason why I believe that wills in general for me is a very important topic. And it's certainly a conversation starter in my family with my brothers, because I remember the property that my mum and dad live in, my dad has built that building brick by brick, and he broke the house down just before or soon after I was born back in 82, and then he built it brick by brick. And the only other people that have come in, specialists, are plumbers and electricians and people like that. And it took him well over 15 years to build that house, because he was the only builder in there. He might have the odd bricklayer every now and then, but he didn't want to project manage it out, so he did it himself. Now I want to keep that building in the house, because we barely saw our dad growing up. That was his sweat and blood in there. And my brothers have already said, no, we're going to do this with it, we're going to do that with it. And I turned around and I remember making a comment to one of my brothers to say, well, actually, I've got a say in this just as much as you have. And he turned around and goes, no, you're only going to get half the share of what we get. And I said, but actually, Dad has already said we're all getting an equal split. So whether you like it or not, I've got an equal share in this. And that was the first time it made me realize that the men are taught that X amount is going to be theirs, and the women. So it's drilled into us for a very long time. And this is where the will section comes into play. Now, before we move on and we talk, I really wanted to just say two things. Now, when you were talking about the person who's making the will, their wishes, their desires, and if somebody doesn't like it, there's certain terminology. Am I correct when I say that if people, let's say someone's passed away and their recipients, which are known as beneficiaries, if they don't like what they've been given, it's known as contentious. Is that correct?
That's right. So then it becomes known as contentious probate because the person has passed away. If they have left a will, the starting point is to look at that document. And as you say, sister, if your father's wishes were to provide an equal share to all of his children, that is within his freedom to do so. But I guess what didn't happen was a consultation with the family to make him or make you all aware that he's going for that choice and the reasons why. So in Surah Baqarah and Surah Nisa, you probably have had the teachings of it, but when I came to it from a reverse angle, if you like, so it hadn't been drilled into me, I hadn't had that benefit of knowing about inheritance, and I wondered why, if everybody knew about it, why would they not? Why didn't my mom and dad have a will? Why didn't all my family members have a will? Why is it that we're having these statistics about the population not having a will, for example? Because you'd think that if it was a farz obligation set out in the Quran and also backed up with the hadiths on how to do it and why it's so important, that you would think, just like we do our zakat every year, and we're in our Ramadan, alhamdulillah, coming to the end, and we've engaged in so many had the opportunity to engage in so many wonderful acts of worship, that we wouldn't go ahead and write our own wills in the way that we should. So I come across people not having will, and that's kind of motivated me to go out and speak and kind of dispel some of the concerns and issues that they have with fulfilling what I consider as like an obligatory act. So for me, I find it rewarding to do it and be a legal practitioner doing it. And I feel that I'm providing a benefit to the other person too. Once they've written it, you know how happy you get if you sign a property deal and you've just purchased a house that you've been saving for or trying to get, and you're so happy you signed it and it's completed and it's in your name, or a car or something that you've been wanting, and you signed that deal and it's legally you own it, right? And you feel so happy. So with my clients, the feeling of happiness when they've signed and witnessed the attestation clause, it's called, at the end, properly and carefully and correctly, and with a kind of wholesome consultation with their family, the kind of peace and happiness that they feel knowing I've done this correctly, everyone's happy with it, and you come to read your will and it isn't contentious then, because you just fulfill the probate aspect of it. So you go through the will, you go to court, get your certificate, and the nice part of distributing to the beneficiaries happily the shares that they wanted. Now, if it's a will that hasn't been made in that kind of style that I'm trying to do in my practice, yes, you will get unhappy people, but within 2 years of death, before it gets really contentious, there's something you can do called a deed of variation. So your siblings together can sit down and change what the deceased person left because of various reasons. So, for example, if somebody had been left out of a will altogether and a sibling says, oh, that's really unfair, mum and dad didn't mean to do that, they must be mistaken. As long as all the people who are legally entitled to inherit agree this, they can create a deed of variation and the distribution will go according to that wish. So it's a post-death wish being activated through a legal document. If there isn't any agreement in that time, or you've missed the time periods to do so, then yes, you will have to go through the contentious route, which involves a court application and then kind of setting out the evidence. And you're at the mercy of the court and the judge at that point then, whether they will agree with you or not. And I think for the Muslim community, it's important to be aware that it's not necessarily beneficial to get to that stage, because it's going to be a struggle for the English court system to understand why it is that the shares are different, why it is that they've been designated that way. And I think it's probably not helpful if the male sector of the community, if you like, who feel like they've got this kind of bonus share or something, that they're kind of going around to advocate or advocate for Islamic rules on the basis that all the men will get more or something like that. Because if you break it down to women and men, if you are an 18-year-old, because that's the first time you're legally allowed to write a will, you can't be, that's one of the criteria, being 18. When you write your will at 18, you might think, oh, I don't really have anything. Why would I write a will? But alhamdulillah, in the UK, we're very lucky. We've got mobile phones. We do have something where Allah subhanahu wa ta'ala would regard it as an asset, even though we might be quite dismissive, but it is something, possessions, clothing,
shoes, anything.
Bank account with even £1 in it is something that we should write a will for. And as an 18-year-old, if you have a mum and a dad, you would write your will to be equal to your mother and father. So there's no, gender disparity or whatever you would call it there. So it's not good to, I guess, make sweeping comments that women get less than men, because it depends very much on the circumstance of each individual.
Oh, trust me, we had a massive conversation there.
Yeah.
I am just going to stop you there for one moment. When you were saying about the deed of variation, isn't that then going against the wishes of the actual individual who drew up the will in the first place? Doesn't that then clash with what Islam would probably say, that respect your elders or respect the other person's wishes? Wouldn't you class that as going against?
So yes, I've looked into that aspect before doing the deed of variations, because I was thinking that, oh yes, you would be going against their wishes. That would be shocking. But there are verses that confirm, if you intermeddle in a person's estate and you do it to create injustice or harm or greediness, or, there's some kind of insincere motivation for changing it, then the person who's doing the changing around and all the parties involved are, not doing a good thing, basically. So it's a big no-no. But if you are intervening to justice as your kind of outcome, and you're doing it for the benefit of the deceased, and you're doing it with the intention of maintaining ties of kinship between your family, and it's something that's agreed by everyone, and you're doing it to avoid court, hardship, worse outcomes. So there's like a balancing assessment that you would go through before you undertake that task. That, is this a good thing to do? Is it the right thing to do? Are we achieving justice as per the Islamic principles of justice? And then you would advise them to go ahead. So if a client was coming forth and they sat down and they wanted to divert everything to a charity for the benefit of their parent, or something like that, naturally you would think that is a good thing to do, but you would have to go through an assessment of whether it's the right thing to do. Because if you are depriving members of family who would need that, that's more of the priority than actually to divert it to charity. And then after that person receives it, their fair share, if they then decide to take the step to give it to charity, that's okay. Because remember, after you've inherited, if you want to jiggle it all around, that's completely your choice, but you have to at least give that person that freedom to choose, right?
Charity starts at home. Absolutely.
Exactly. Yeah, it's a step-by-step process. So I always take each case on its own and see how it goes.
Okay. So because time's actually flying, so we've got about 16 minutes, so we've got quite lots to cover here. Now, I really want our listeners to understand that if there's not a will in place, because we do live in England and Wales, and it's the laws of England and Wales that will apply, there is something known as the Intestacy Rules. Now, I don't want you to get into the nitty-gritty of the Intestacy Rules, because we're not here to give legal advice to our listeners. But what I do want you to just quickly touch upon is what happens if there's no will, but there is property that's left behind by a person. What does, in a nutshell, like in 1 or 2 sentences, can you quickly sum up what intestate means?
So that means you haven't written a will. And in that circumstance, the law of England and Wales does come in to provide a set of rules about who's going to be in charge of your will, is the first step, because there's no executor in the will. You're an administrator and there's a list of people. And then the second step is, where's everything going to go? And I try to post on my social media like little helpful charts and things, because I appreciate it is complex. So I like to give a little insight into things which may be informative for the Muslim community. So the distribution which works out isn't Sharia compliant. So that's even more of a reason to create a will for the Muslim community. But also for my non-Muslim clients, it's often not what they want either. So because it patches things up in different ways, and it can end up down a path that, you know, towards uncles, aunts, siblings that you wouldn't imagine your couple. You know, another thing is whether you're married or not has an impact as well, because law of England and Wales does encourage marriage. The exemptions for tax are very generous, and you know, it's potentially a tax-free if your spouse is. But of course, if you're not registered married and you're not regarded as a spouse couple, then that can have issues for my non-Muslim clients, and it doesn't go according to how they want it. So
also,
that's the worry, really.
Sorry to interrupt your thought there, but also stepchildren. I think a lot of people don't realize that the laws of England and Wales when it comes to the intestacy rules. So basically, very quickly in a nutshell, if there's no will, and let's say if a father was to pass away, then automatically, if the wife is still alive, the mum, let's say, then the mum would automatically get everything, right?
Not everything, but they get like a statutory sum of 270,000. So that's like a ring fence sum.
Okay, that's something new I did not know.
Oh, okay. No, so yeah, it is quite technical, but then I'll be talking about the intestacy rules for a really long time. But it doesn't all automatically go. So that's another misconception, misunderstanding. It also depends how you hold your assets, the accounts and the properties. So the law of property does sometimes override the law of wills. There's an interplay between that. So again, it's quite good. Yeah, it depends on intricate. How you own it, how much you have, how it will go.
Yeah. So okay. So that I did not know that. So I'm really glad that you myth busted that one, because I actually thought automatically it will go everything to the next person, the spouse who's still alive. But what I really wanted to actually mention is stepchildren. So let's say let's just say, for example, my husband, you know, me and my husband were married, but my kids are not, he's not adopted them because their birth father's still in play. So my kids are his stepchildren. If he was to pass away, I'll give him a very long life, but he left intestate, so no will, my kids would be very, very bottom of the food chain of getting something from him, because his mum, his sisters, his brothers, his uncle, aunties, grandmother, grandparents, they will all come first before his stepchildren come into play. And I think that's quite something that I really wanted to get out there, that if you've got one of those, I think it's known as a hybrid family. If you've got one of those type of families where
blended family,
blended, that's it, family, yeah. If you've got a blended family where you're not necessarily have adopted that child, or you might be taking care of a cousin's child, but you treat that person as your own, England and Wales will not recognise that child immediately. You know, they are very bottom of the food chain, as I like to say. So it is quite crucial, and these are the differences as well. So the next the next question I wanted to ask you is, we've already touched upon some of the differences between English wills and an Islamic will. Is there anything particular that you wanted to explain that is a substantial difference between the two wills?
I think the major difference to know is that the perspective of it. So an English will is your total freedom to distribute your asset as you wish. So you have to be domiciled, in England and Wales for tax purposes to be writing this will, which most people will if you're living here, you're born here, or you're resident here. You have the freedom to write your will as you wish. Okay, so no one's going to take that away from you. That's the law of the land. You can go with that choice, and that's essentially your own self-interested legal right to do so. Then you have what is under Islam, the Islamic perspective that Allah subhanahu wa ta'ala has provided us for mankind as a kind of gift to know this is the fixed share, these are the set limits, this is how Allah would like you to do it, and He knows best how it will impact you in the afterlife. And we cannot even, we can't contemplate what the afterlife will look like or how it will be for us, but we know there is one as believers. So that's kind of our target goal is a bit different, because we're aiming for that, to be successful in the afterlife. And the shares on how to do it are very definitive, and they're prescribed in Surah Nisa. And like you said, you've had the inheritance learning in Islam, and you can learn it as well. And I do encourage actually my clients to learn it and know it and come to me. The best clients that come to me, they know about it, and they're like, Allah has said to do this, and I would like to do this. And then we go through an assessment of how we can achieve that in the most harmonious way for that set of family circumstances. So the hadiths provide us with the flexibility of about 1/3 of your estate is the wasiya, the will in Islam. So you have this 33% that you can do as you wish with if you want to. Leave it all to charity, give it to others that may not be within the fixed shares, but the other 2/3 of the estate should go per the Quran and Sunnah fixed shares. And if you go to a country like Scotland or other countries, they will have fixed shares too. So I guess that's the difference, to know that in England you have that full freedom. But it can still be challenged afterwards, so don't forget that. And then in Islam, Allah subhanahu wa ta'ala has given us a blessing and a guidance that is for our benefit for the afterlife. And there are hadiths that confirm, a person can live through their life for 70 years, okay, and they're doing all of their good deeds and they're stacking up their rewards. But when it comes to their last will and testament, they've been unjust. And that's a devastating consequence. And then if you live 70 years, not quite, getting it right, maybe not quite aware, maybe whatever reasons, but then you're fair and you're correct in your last will and testament, the garden destination of Jannah is sealed for you. And that's a hadith. So that is a real motivating verse for me to kind of recognize the difference there, where I'm targeting my clients for.
Well, Islam teaches us honesty, doesn't it? And intention and fairness. Those are the key fundamentals of Islam, which I suppose when it does come to estates and property and money, jaidat, as people say in Urdu and Gujarati, it really does blind people to a certain extent, because people don't take certain things into consideration. Now, if let's say, I've got an English will, let's put it that way, because I want the freedom to do with my items as I choose to wish. And to be fair, when I actually made my English will, Islamic wills wasn't as prominent. It wasn't, there wasn't a full awareness of it. I actually didn't know that such a thing as an Islamic will exists. But if I was to say, as a person, choose to draw up my will in that sense, as opposed to doing it the 33%, the 2/3, you might not know this answer. So if you don't, because I appreciate you're not an ulama, but am I actually doing something wrong in accordance to Islam? Am I, getting myself in guna because I've not followed the Sharia compliant way? But actually my will is very fair. I've tried to leave as much as I can to quite a few people in my family, as opposed to the fixed type of shares. Is there anything wrong, or...
So that's part of the service, actually, what I do, sister. So, for example, obviously it's a confidential service. You share and my service is remote as well. So I operate not only nationally, but say internationally. When I set up, I was thinking, there's so many providers at the moment currently of Islamic wills, and they do it slightly differently. But for me, because I had a different motivation, my first client was CEO of a major bank in the Middle East. Wow. And I would have never, I didn't even try to get him as a client or something like that. He just arrived and I was like, wow, okay, first client, majorly rich, what to do. So, and he had, different wishes that were not necessarily Sharia compliant. And then I prepared a kind of procedure, if you like. So a checklist way of going through this. How can we get to the outcome? So it starts off with sending me across what will you do have. What are your concerns with it? What would it look like if it was Sharia compliant? And what would it look like if it stays as it is? And then talk about the outcomes with you directly. And then I have a network of kind of scholars and more established practitioners, both in English law, so that, 20, 30 years they've been doing English wills, and they've also seen the kind of challenges that people can face if people are left unhappy, and how those cases work out, and also a network of scholars. So they're covering all the different schools of thought and the little intricacies of what you may be worried about, is wrong, but wrong is a very subjective word, and also ultimately the judgment is for Muslims with Allah subhanahu wa ta'ala. So he's going to decide what is judge. I'm not going to decide. We can only strive to do what will please him and why it will please him, and kind of increase our understanding of that and get to the point where you're happy with it as well. And it makes sense. And if it doesn't, I would be surprised if people would be saying, like, this is wrong, cross it out and put it in the bin, because, that's not our place to do that for any matter. So, so, I don't know.
I appreciate that. That's quite interesting. But like I said, for me at the time when I was drawing mine up, it was quite a while ago, and Islamic wills wasn't as prominent as it is now. Now, one thing that you did mention about Islamic wills, where what you encourage is where the family sits down. So let's just say, for example, I want to sit down with my children and I want to tell them I want to leave X, Y, and Z to X, Y, and Z people. But that gives them the opportunity to turn around and give me their wishes, to say, no, but I want this and I want that. Tell me, why should I, as the person leaving those items, listen to them when this is, let's just say, my property, my house? I've worked hard to make this money, have this house, have that car, have that motorbike, have that number plate, because I do love my number plates. Why should I listen to, say, one child over the other child? Because their differences are going to be quite different. Why can't I write the will and they be happy with it?
Yeah, so I guess the easy answer is yes, you can. So alhamdulillah, Allah subhanahu wa ta'ala has blessed you with kind of assets and luxuries and things which are pleasurable and enjoyable, and you've got them and they're yours. And yes, in your will, you can distribute it as you wish without consultation with them. But I guess if you're thinking that you ultimately want to benefit somebody, so that you're not going to take these items with you to the grave, these items are not going to speak on your behalf to kind of pray for you or do anything at all that could in any way benefit you, because there are only three things from the hadiths that I've studied, which is a child praying for you, sadaqah jariyah in your name, or some kind of beneficial knowledge that you've left behind that others can tap into and use over years to come. That's it. So when it's just kind of restricted to those three things, I guess you might think, okay, I want to leave them in a way that they will be pleased with me and they'll be praying for me at the time of my death, rather than thinking, mate, she just left all the stuff to him or her.
Rather than fighting over it. It's like that age-old. It's that
this kind of because it's human nature. So I will feel like, why did she do that? Or why did he not think of me? And
she's definitely the favourite child. I get that all the time. So I'm conscious of the time. We've got about 2 minutes and 10 seconds on the clock. So I do apologise for interrupting you again. I seem to have done that a lot today.
It's been really lovely to kind of speak about it.
Time's going really quickly, that's for sure. So one of the other questions I had in mind is, what should people be mindful of? Are you able to sum that up in about 40 seconds or so?
Yep, let's go. So mindful, of course, of your family's wishes, but remembering that it is your own uninfluenced total wish, how you want to set out your will in England and Wales. And then be mindful of the different tax implications that might come into play depending on how you distribute the estate as well. And also just to be taking professional advice. So a lot of people will say, I've written it myself, or I've done it online through cheaper services. And I think a lot comes out through discussion, because people should review their wills every 3 to 5 years, make sure it's up to date, and then consult professionals. So make sure they're regulated professionals by Society of Will Writers, SRA, Institute of Will Writers. I mean, there's lots of them that are regulated, and then you've got that high quality personalized advice,
Yeah, sure. So one of the things I did want to say is, what about writing on a piece of tissue issue. And for those listeners, you know, who have tuned in today, just to let you know that sometimes even those kind of written items have been challenged in court.
Of course. Or they can end up valid. I mean, that's the other thing.
They have. So, you know, an agreement was made to say, I'm going to leave you my 2 watches, and it was written down on a piece of paper. So definitely get certain advice, and also remember that Islamic wills is about, it's not about unfairness. It's about following the Quran, the Hadith, the fiqh. It's following what Islam says, what Allah teaches us, and what the Prophet was teaching us. So we've got about 10 seconds. I am going to sign off now. Jazakallah so much, Yasmin, for joining us on Islamic Wills on Ramadan Radio 87.7 FM. I do appreciate